You're tuned in to Agriculture Today, and we start our Wednesday show talking about legal scenarios people in agriculture may experience with K-State and Washburn law professor Roger McEowen. Roger, thanks for joining us today.
Thanks for having me, Shelby.
Roger, in this article titled More Legal Scenarios Involving Farmers and Ranchers, one of the points you make in here involves self-defense, and as we're thinking about it for agriculture, what are we talking about?
Well, I think it is a fairly common question in ag settings, and that is how far can you go in defending your personal property, such as your machinery and your equipment and those types of things that are out in the open often. What can we do to protect those from people that would cause damage or steal them? We don't always, at the end of a day's work, button up all our machinery and lock things down. We may leave things sitting in a field. We may leave them in an unsecured barn or a lean-to, for example, and so it raises this question. And we're operating in remote areas to begin with, so they kind of lends themselves to those people that are inclined to do these things, to vandalize them. So what can we do to protect our property against that type of conduct?
And how far can these people go?
Well, that's a real good question. Where do we draw the line? And in general, that line is drawn with matching force with force. And what I mean by that is you have the right to use force in protection of your personal property that is reasonably necessary under the circumstances. But you can't use force beyond what could reasonably be believed under the circumstances, and you can't use such force that would likely lead to great bodily injury or death if your life is not threatened. And that's often the case with personal property. We're not even around. It's sitting in a remote area, and our lives are not threatened. We may not even know when someone is around that is going to vandalize the property. So we can't use excessive force, and we can't use force to protect that property that's more than the force that's used against us. And so that's the tricky part of this. If my life is not threatened, then I can't use an instrumentality that would threaten somebody else's life in protection of my personal property.
And as you've mentioned, using force, that force can be an animal, and how do the rules and laws play around that?
Well, indeed, it could be. You have to be careful, for example, using guard dogs to ward off trespassers. And guardian dogs are used, for example, to protect livestock. Well, the general rule with respect to guard dogs is that you can't use any more force through an animal than you could personally. So if a guard dog injures or kills an intruder, it's the same as if you had done it. And the same thing applies in terms of liability for a dog's what we call dangerous propensities. You can't avoid that by posting a sign notifying trespassers of a dangerous dog's presence. And there's plenty of cases on that have occurred over the years. So the protection of personal property, machinery, equipment, personal belongings, those types of things, as well as livestock, they're all treated under the same rule. We can meet force with force. We can't use excessive force. And then we get all types of different scenarios that can come up. The questions that I get on this seemingly are endless because every situation is unique. But that's the general principle in exercising self-defense. I would say, Shelby, that perhaps the most famous case on this whole issue came out of Iowa in the early 1970s. It was an Iowa Supreme Court opinion back in 1971 that really laid down the black-letter law on this that says that you can't use force that could physically harm or kill someone else in defending your personal property if your life isn't threatened. And what that was an abandoned farmhouse. The Brineys, in this case, they were farmland owners in south central Iowa. And Mrs. Briney had inherited her family's place, and on it was the old homestead, which was miles away from their place. So there were no neighbors around. And they used that old farmhouse to store personal belongings in, and a lot of antiques and those types of things. Well, it constantly was vandalized. And this went on over a 10-year period, and they got fed up with it. They posted signs. They boarded up the windows. They tried all types of things, and the vandalism didn't stop. And finally, Mr. Briney went upstairs and wired a 20-gauge shotgun to the bedpost, and the trigger was wired by a string to the bedroom door so that when the door opened, it pulled the trigger and would shoot the intruder. And that's exactly what happened. And they got sued, and they lost. In fact, had to sell the farm to pay the judgment. Just a horrible situation. The court said, look, you can't defend your personal property with an instrument that could create great bodily harm or death to somebody else when your life isn't threatened. So we've got to be careful on these types of things.
And Roger, we've talked about protecting that property, but what about if it's someone protecting themselves from an animal?
Well, every state, including Kansas, has what we call a dog kill statute, and that is a statute that governs the situation and deals with the question of when can I shoot a trespassing dog. Well, the statute in Kansas, as well as other states, tie it to being able to shoot a dog that's trespassing, that is doing certain things that are enumerated in the statute, to domesticated livestock. So harming, chasing, maiming, and even the Kansas statute says worrying domesticated livestock. Now, there's no explanation as to what worrying means, and you can kind of scratch your head over that one. Do cows worry? I don't know. But apparently the legislature thought they did. But the point is, you have to, if you're going to shoot a dog that's trespassing, you have to catch them in the act. You have to shoot them in the act of doing what the statute prescribes. And so it becomes an evidentiary issue. So if you have a dog that is, say, a neighbor's dog that is just trespassing on your property, you can't shoot the dog unless they are caught in the act of harming domesticated livestock in one fashion or another.
And we've mentioned having guard dogs and livestock guardian dogs. So what if one of those animals takes action against another domesticated dog or other animal?
So if you have, for example, a dog that's trespassing into a pasture that has, let's say, sheep that are being guarded by your guardian dog, and your guardian dog goes after that dog and takes it out, it's the same question then as to if you shoot the dog, are you covered by the dog kill statute? And you're going to have to prove that your guardian dog, which did what it was supposed to do, what it's trained to do, protect the livestock, did it kill that dog while that dog was in the act of harming the livestock? Most likely the answer is yes, but you better be able to prove it, because what's going to happen is you'll probably get charged with cruelty to animals using your guardian dog as an instrument, or of yourself, or damage to property, and then you'll have to raise the dog kill statute as a defense. And if the dog were to attack you, we've got a stand your ground law in Kansas, and again, you can raise that as a defense, that I didn't have to get away, I can stand my ground, and once I feel my life is threatened, I have the right to shoot the dog. But you have to prove that. You can't just shoot the dog. You have to be able to raise that as a defense to a charge of cruelty to animals or damage to property.
So, Roger, in all these scenarios, really important to have evidence or reasoning behind your actions?
It certainly is. Everybody's got a phone that has a camera on it just about these days. You may not have it with you, but you need that in these types of situations so that you have some evidence that you can show a judge or a jury that you acted appropriately. One of the worst things we can do, beyond not just having evidence, is to just shoot, shovel, and shut up. That is not a good approach. I know that's done in reality, but that can come back to bite you.
Roger, I want to talk about another point you made in this article when it comes to different legal issues, and this one involving the Good Samaritan Laws and a case that really made this come to fruition.
That's right. Good Samaritan Laws really arose from a case that happened in Queens, New York back in 1964. It's the famous Kitty Genovese case. And she had returned home from work in the wee hours of the early morning, and she lived in an apartment complex in Queens, and she was attacked. And there were over 50 people that heard her screams and witnessed the attack from behind their curtains in their apartments, and nobody did anything until it was too late. And they said that, well, we didn't want to get involved because we feared liability. And she did die from this. And eventually the individual was caught, by the way, and prosecuted. And he went to prison. And that event helped spur the enactment in every state in this country of what are called Good Samaritan Laws. And what that means is the law wants to encourage people to aid people that are in need of help. And so what the laws say is, and the Kansas law is like this too, if you help a person that's in peril without expectation of being paid, then you can only be held liable for injuries resulting from recklessness or willful intent to injure. So it's a pretty tough standard for somebody to overcome if they're going to sue you saying, well, you were responsible for this person's injuries. Well, no, I tried to help. And so as long as I didn't help recklessly or with intent to injure them, I'm not liable for their injuries. And that's designed to make sure people just don't do anything. Now, you still don't have to do anything. It's just trying to create an incentive for you to do something and not fear liability. And the state laws also provide slightly different treatment for emergency medical technicians and hospital staff. In some states, they have an affirmative duty to render aid when they find someone in peril.
How does this Good Samaritan law apply to agriculture and livestock?
Well, the same rules would apply if you see livestock in peril, and particularly if you have knowledge of how to help them. If you render aid, you won't be held liable unless you do so negligently or as the law states, recklessly or with intent to injure.
Roger, I appreciate you taking the time to join us today and talk about a few points in your recent article.
Thank you, Shelby. My pleasure.
That was K-State and Washburn law professor Roger McEowen. I will link his blog article titled More Legal Scenarios Involving Farmers and Ranchers in today's show notes on agtoday.net, where you can also find it by going to washburnlaw.edu/WALTR.